Hello, everyone, and welcome to this week's edition of Accessibility News, where Tracey, Delisle, and myself bring on guests with different perspectives to talk about different topics, all within the accessibility realm. For those of you joining for the first time, my name is Glen Ingram. I own a couple of companies in the website accessibility niche. We're just trying to help make sure that the website or the internet can be more accessible, one website at a time. Tracey, how are you today?
I'm doing great. Thank you so much. Happy Friday. Yep, my name is Tracey Delisle. I'm with Certified Access Services, and we are a team of CASP inspectors, and we cover all of California. We provide CASP inspections, consultation, accessibility plan review, and then we also do seminars to help businesses understand the importance of accessibility. Harrison, how are you?
Good. Thanks for having me. My name is Harrison Thorne. I'm an attorney with Shepherd Mullen in Los Angeles. I primarily practice labor and employment law, focusing on litigation and advice and counsel. And kind of subsumed within that, I do a lot of ADA website accessibility litigation.
Hi, everyone. I'm Sean Kirby, and I'm also with Shepherd Mullen. I'm based out of its New York office. I also am a labor and employment attorney. I do a lot of advice and counseling and litigation on the employment side, but a good portion of my practice has been over the past few years ADA website accessibility, as well as your typical brick and mortar ADA defense.
Well, welcome, you guys. Thank you for arriving today. And I noticed that you said you both work for Shepherd Mullen. Congrats. Not easy to get into that firm. So it means you guys are pretty smart, because I know the requirements to get into Shepherd Mullen. So congrats.
Thank you.
Thank you.
So let's kind of talk about where you guys see everything with regards to accessibility, and whether it be physical or digital. And maybe we can talk a little bit about both of those here in July 2021.
All right, Harrison, if you want to jump in first from the California perspective.
Sure. So, what we kind of have noticed is a steady uptick in website accessibility lawsuits, and there's kind of a growing number of these cases coming out of the same firms with the same plaintiffs. And the trend is, or seems to be, litigants pushing various theories and kind of testing to see what sticks. There was, for a time, a trend of litigants bringing suits claiming that, for instance, gift cards that didn't have Braille on them violated the ADA. Then that seems to have passed somewhat. Maybe, Sean, you have a different experience with that. So it seems to be a boundary pushing issue. Meanwhile, there are people with legitimate disability claims that sometimes get overlooked based on the often frivolous nature of these lawsuits. So that's been kind of what I'm seeing.
Yeah, and in New York, we're seeing the same sort of thing. There are a handful of plaintiffs who bring a large number of lawsuits, particularly in the ADA website accessibility realm. Last year, there was a big push to Braille gift cards. The claim was that Braille gift cards, gift cards need to be in Braille to be accessible. Those are currently on appeal at the Second Circuit Court of Appeals. So at the trial court stage, many of those claims were dismissed with the finding that gift cards are not a public accommodation, place of public accommodation. That's currently on appeal at the Second Circuit. So we're waiting to see what comes out there. But we're seeing the same sort of thing. There's been a large uptick in the past few months of website accessibility cases. There has been a trend recently of cases focusing more on mobile applications instead of websites. But it's the same sort of claim. It's just looking at the mobile application instead of the website.
Now, what I'm interested, since we're lucky and fortunate to have two people with the same company at different coasts, I wonder if you guys communicate back and forth and see the same things that I'm kind of seeing, when all of a sudden you'll have a plaintiff in New York, like 2 years ago, that started going after wineries. And then all of a sudden, within about 6 to 9 months, we see wineries start being sued in California. Or last summer in Florida, it was real estate companies that were being sued in property management. Then all of a sudden, the first year in California, we start seeing real estate and property management. It's kind of like all of these plaintiffs or their representatives have access to the same information. And when they see a new industry, someone else kind of follows suit. What are you guys seeing with something like that?
Yeah, no, we say the same thing. These plaintiff firms, I believe, typically follow the dockets of the hot jurisdictions. So they follow the dockets in the Southern District of New York. There's a lot of cases there. Same with California, same with Florida. So it's not a coincidence that you see a lot of copycat lawsuits when it comes to different industries. They're all watching the same thing and seeing who's being sued.
I have a question regarding the differences in California and New York. I know there are a lot of advantages for the law firms, of course, in the state of California, because I was born and raised here. I can call it crazy California, which I do every week. But is there a lot of advantages for the law firms in New York like there are in California?
So California, a lot of claims are brought under the UNRU law, which provides for the statutory damages of,
right.
I believe there's 4,000 per incidence. New York doesn't have that. New York doesn't have that. So most of the claims in New York are brought under the ADA, which just allows for injunctive relief. And then there are always tack-on claims under the New York State and the New York City human rights law, but they don't have the same sort of statutory damages penalty that the UNRU Act has. So in New York, those claims are harder to win. You need to prove emotional distress. You need to show that you were damaged as a result of not being able to access the website. So it's not, you're better off with an UNRU claim than you would be with a New York State or city human rights law claim.
So would that make the settlements on that higher or lower?
So unfortunately, we can't talk settlements. That's confidential.
Got it. So yeah, we have averages here for sure that we see, a range of the settlements here, and they all seem to be around, depending on the firm that's filing these claims. You kind of know where it was going to fall, or what I call is their threshold. So yeah, it's interesting to know that it seems to be a little bit harder in New York than it does in California. Would you agree with that, Harrison, as well?
Yeah, definitely. I mean, California is kind of the mecca for these cases, I think. And, what Sean said, the UNRU Act, if you violate the UNRU Act, you violated the ADA and you get the statutory damages. There's attorney's fees issues. So it's really attractive for these law firms to kind of center out here and bring their cases out here. Not saying they don't elsewhere, but, in my experience, California is kind of the hotbed for it.
In New York, do you see what we see sometimes with some of these plaintiff representatives in California, where you have some that have a model to where they actually send demand letters prior to filing? That way they're doing a higher volume. Those typically settle a little bit quicker because they haven't incurred the expense of filing fees and document fees and stuff like that. Do you guys also have that in New York?
Yeah, some firms do. It's not as popular as it is in California. In New York, you tend to see them go right to filing the lawsuit. Rather than sending the demand letter, but some do, but it's not as common as you'd see in California.
Gotcha.
Yeah, and I'll say, Glenn, as well to that. All of the clients, it just so happens that I've worked with directly in the last couple of months or even years, all of them have been in the process of taking steps to ensure that their websites are accessible, and then no deed goes unpunished. They get, served or sent a demand letter from one of these attorneys. And, so all the clients I've worked with have been so kind of annoyed and enraged. Like, well, look, we're spending all this money to kind of comply with these sometimes nebulous guidelines, the WCAG standards. And, now we get sued. What's going on here? So I don't think those demand letters tend to move the needle, and people usually say, pound sand and let's go to court because we're doing what we need to do.
Well, that brings up an interesting question that I've been a part of, because we were in the process of working with a company that wanted to do the right thing and take care of this. And literally within a week of their site being completed, or days, they actually received a complaint from the state of New York. So does that help them that within like I said, days of receiving a complaint that their site is actually accessible? So are they just guilty until proven innocent because at the date that the complaint was filed, they weren't accessible? Or how does something like that kind of work out in either state?
Yeah. So in New York, since we don't have the statutory penalty like you do in California for the UNRU, if a company is able to make modifications to their website to make it more accessible to the visually impaired, in theory, you can make a motion to dismiss for lack of standing, basically mootness, right? So under the ADA, all you can get is injunctive relief. So if you're able to address the issues that they raise in their complaint and make them moot, then you have a viable motion to say that there's no longer any relief you can get under the ADA.
Mm-hmm.
And then the state and city law claims would fall with those because there's no jurisdiction in federal court once you get rid of the federal claim.
Okay. So in New York, definitely the quicker response, the quicker you can do this, the better it's going to be for them typically financially.
So yeah, if you can make the modifications to your website and rectify those issues, then you would have a good basis to bring a motion, and also your website will be functioning better for the visually impaired. So you have the two aspects of it. You have a potential litigation benefit, and also you want your website to be accessible for your customers.
Amen. You're preaching to the choir here. We always try and explain to them that not only is this protecting you from litigation, but the increased exposure to the whatever numbers you're looking at, 20, 23, 24% of the population that now can become clients that have a little bit of money in their pocket. It's definitely beneficial for the business. Harrison, how about you in California? What are you seeing from some of these things, or as far as expeditious remediation of these and where they're at in the process and stuff like that, as far as their, I guess, maybe limiting liability, or does it change much?
Kind of to add what Sean said, I agree. I think in California, the framework is pretty similar. With the unroot claims, I know a lot of practitioners were kind of theorizing, look, if someone sues in California state court, let's try to remove to federal court. Then let's remediate, let's fix the website as best we can and hope that we can apply the mootness doctrine to, so that the district court would find there's no standing, there's no jurisdiction. But, as it turns out, it's very, very, very difficult to moot one of these claims. Especially as you guys know, like I said before, the WCAG standards are somewhat nebulous, and it's hard to know what exactly compliance requires. So mooting one of these claims is exceedingly difficult. And there hasn't been a lot of case on this, but, from what I've seen, that looks to be the case. So best practice, if you get hit with one of these lawsuits, would be to take steps to, modify, not just so that your customers have the, more accessible website, but also to kind of increase your chances of mitigating any kind of damage, finding, and doing the best you can.
Go ahead. Well, that brings up a question in regards to other type of media in California. So we understand that there are some standards for websites, but what are the standards for mobile apps and things like that? And what should businesses be looking for to even know if, what they're putting out there is correct? Is there somewhere that they're looking? Because I'm starting to hear more and more about mobile apps and different devices. Now it's not just websites. So what's your advice on that, and where should they be looking? And who would they look to for that? That would be for Harrison.
To you
just
guys.
Because of California. Okay.
Yeah, to you guys. No, WCAG guidelines are a good starting point. There's a lot of companies that we work with pretty closely that kind of help companies with this. A client recently had a subscription website service, and they're kind of wondering, how do we make sure that our website is complying, but also the subscription kind of sub-service is complying. So it's an evolving area, and I think the difficult aspect of making a kind of clear-cut rule for what companies have to do is that as technology changes, and it changes all the time, it's hard to kind of make a rigid structure and framework. So my best advice would be find a company that is really experienced in ADA kind of compliance and work with them closely and on an ongoing basis to make sure that you're always kind of compliant or as compliant as one can be.
So Glen, are you helping people with app type systems within your company? I guess we haven't really talked about that before because we've always been so focused on the website on your side of it.
No, we don't do apps primarily because we work typically with small and mid-sized businesses. And the reality of it is most small and mid-sized businesses, the juice isn't really worth the squeeze for an app. I mean, they're going to spend so much money, so much time driving people to using an app that they're never going to get the release back out of it. So it's one of those things where more often than not, when someone comes to us wants one, we dissuade them from spending money on it because there's better ways for them to utilize their advertising dollars. But I think what's interesting with this when it comes to lawsuits is you don't have testing tools to test a website. So for a lot of these serial litigants that are out doing a lot of these, in order for them to know if an app is not accessible, they actually have to have someone that either understands it enough or that truly has the disability to go in to test it to find out what's wrong with it. And where 98% of websites aren't accessible, I'm willing to bet that 99.9% of apps are not accessible because, again, most of the people that are doing the coding aren't familiar with ARIA. They aren't familiar with semantic HTML. So they're just not going to know what they need to do to make these apps accessible because, again, unfortunately, in the development community, there still is not enough information out there about this and enough people taking it seriously.
Wow. Sean, what is, if a website is just an informational website? Like, let's say it doesn't sell anything, you can't make a reservation, it's just kind of an informational about, this is our company and I'm just, giving you information about us.
What's
the difference there? Because I know that's kind of where the lawsuits get kind of crazy is when people try to do something on it.
Right. So, the ADA, public accommodation is a loose definition is someone who sells goods and services to the public, right? So if it's just a purely informational website, you'd have an argument that the ADA doesn't apply to it, right? It's not selling goods and services to the public. The tricky part gets into, what is displayed on this website, right? Is there a way to, does it have contact numbers where you can purchase goods and services? So there's a lot more nitty gritty when it comes to that. But if it's just purely informational, like a website that basically has nothing on it, then you have a decent argument that the ADA wouldn't even apply.
Right. I asked that because I deal with a lot of restaurants in San Diego and throughout California. And one of the big things you don't find, I'm just going to, put my name on there and, describe what type of food, that we offer at this restaurant. Let's say it's Mediterranean and call it a day. I'm not going to allow them to order anything on there anymore because that industry in particular and hospitality of hotels and things like that are hit the hardest. And so I'm hearing that a lot. And so accessibility of the websites is not my realm. I'm more of the architectural, here in California, but that I always just kind of shrug and say, you need to run that by your legal and ask them how they're going to be able to support you in that. But that's interesting. Would you say the same thing, Harrison, California, is that's a response is the same across the board or across the states in this case?
I think it's the same across the board. Another thing to be mindful of is the physical nexus. So there's kind of a contested issue now, whether or not a website is governed by the ADA if there's no brick and mortar location. So, a store is pretty uncontroversially a place of public accommodation, I think. And the question becomes, what if an online business truly has no brick and mortar location, but they sell goods online? And there's some good authority in California in the Ninth Circuit that, no, in fact, you have to have that nexus to a brick and mortar. And we've had some success there, but that seems to be changing and is likely to continue to change. So that's, another thing to keep in mind as well. What's the tie-in to a physical business? There's a lot of things to be mindful of. So there's no easy way to answer that question. And when in doubt, talk to a lawyer.
Yeah, I say the same thing to them. I said, it sounds like an idea to me, but I would definitely touch base with your legal because at the end of the day, they're going to have to defend it. So, if anything, help build the case if they do have to defend it. So,
speaking of change, I'd like to hear from both of you what your opinion is moving forward with this industry, if you will, because I know from doing a lot of research, I've seen a lot of different circuits open up since the Domino's decision. I know we had like 52 lawsuits in Colorado last year. Illinois, Pennsylvania, Massachusetts have both increased drastically over the last 18 to 20 months. I'm very shocked with all the publicity that came out of DC in February about their site being accessible where their predecessor wasn't accessible, that this hasn't been inked black and white under Title III. So what are your guys' opinions and what do you foresee working in this going forward with either a copy, black and white within Title III, and or just how this is growing with or without that?
Yeah, so I expect to see basically the same thing over the next few years until either the government, makes black and white, the websites are covered by the ADA, or the Supreme Court issues an opinion on it. As you know, the 11th Circuit recently had the Winn-Dixie opinion where they flat out said websites are not covered by the ADA. So there's clearly a circuit split right now between Ninth Circuit, 11th Circuit, and a lot of district courts also are kind of all over the place on this issue. So I think until we get a definitive ruling from the Supreme Court, or the government steps in and actually, makes a law or amends the ADA, I think we're going to still see the same thing. A lot of lawsuits about this issue because it's really a gray area right
Yeah.
Yeah, and I agree with that. I think there was a push recently in Congress and it had bipartisan support. I think it was sponsored by a Republican and a Democrat, but it didn't go anywhere. And I think at this moment in time, with politics being what they are, and as serious of an issue as this is for people with disabilities, it's just not something that's likely to move the needle, given all the priorities and things going on right now. So I think that if anything, it would be a Supreme Court issue. But again, there's a lot going on that needs to be addressed by the Supreme Court as well. So I agree with Sean. I think the status quo will probably remain for quite a while.
I'm just disappointed because I think realistically, this seems like the DOJ has been involved in more of this, over the last 12 years than any other kind of organization or department in DC. And literally, it would have been a copy and paste from a couple of pages of 508 to Title III, and this would be done in a moot point. We would have clear-cut guidelines and have compliance officers that can argue for their plaintiffs and stuff like this. It just seems like it wouldn't be difficult to fix.
Yeah.
But maybe that's too logical.
Maybe.
Yeah.
Then as Harrison said a few times, if the WCAG standards were to be adopted, for example, they're nebulous. They're not clear cut either. So I think there's always going to be litigation about this. Whether or not a certain aspect of a website, if the standards are WCAG is ultimately adopted, whether or not the website even meets those standards, right? So I think this is always going to be an issue. But obviously, if clear-cut standards are adopted, then you know what you're dealing with, right? It would be more like a brick-and-mortar ADA type case. You know what standards are, and it's whether or not you meet them.
Yeah, I think that's why I referenced 508, because 508 has the compliance officer, and we basically act as behalf of our clients as a compliance officer with understanding this, so that we could talk with you guys and say, what obstacles did they truly encumber, and then we can say, we're going through this, we don't see this type of thing. So it's always going to be fun to see how things twist and turn through the great DC.
Oh, yes. I have a question regarding CASP. We have a program here in California. It's a CASP program where we go out and we give some benefits. Does New York have a program like this?
No, I'm not familiar with such a program in New York.
Gotcha. So, Harrison, the question would be to you is, once somebody files a claim, and then they go get a CASP inspection, and we're talking about specifically architectural barriers. How does the CASP help them, or why even get it at that point?
Well, first with the caveat that physical architectural ADA is not my specialty, so getting that out of the way, I think there's a statutory kind of guidelines which would allow you to avoid some liability. So there's the benefit there. Also, I think companies want to do the right thing. Oftentimes, they want to make sure that they're complying with the law. So there's that as well.
Right. So we're seeing a lot of in California right now, a lot of these cases that are not valid for architectural barriers, and one of the reasons is they'll use Google Earth, or they'll use some sort of media like that. And so we go out, and one of the things that we do as part of our service, we'll do what's called a validation letter. We take a look at the claim, and we'll go out there and make sure that it's valid. And I'm seeing a string of cases that are not valid. In a case like that, what is the advice from you to for a client? Do they then take that letter to their lawyer and then just make a phone call to the firm, or what is the procedure on something like that? Since it's fairly new, I haven't been able to kind of guide them or understand what a lawyer would do at that point.
I think it depends. I think the benefit of working with a practitioner who has a lot of experience in this area is, like Sean said, the plaintiff's attorneys in this arena are often repeat players, as are the litigants. So if I know plaintiff's firm X, Y, and Z are receptive to a phone call and say, hey, this is not a meritorious case. Let's just, let's get this off the docket. But I know the ones that aren't. So the benefit of going to an attorney who has experience would be kind of letting you determine how to move forward in the most effective way and the most painless way. So that's kind of how I'd recommend starting out.
Yeah, and I'm always the one is like, listen, we can just identify whether that violation exists or not, but always the next step is to reach out to legal. I'm a big fan of that they're not trying to do it themselves. I understand why they want to. I mean, business is tough right now. But my push is to reach out and make sure that you're covered and make sure that it's actually closed. We had somebody who tried to deal with it themselves and thought, well, the guy said, okay, it's done, but it actually wasn't. And then they went on to court, and then all of a sudden they got some ugly letters right after that. So I'm always a very big advocate of making sure that they close that case and make sure that it's completely done. Are you seeing any of the cases go to the early evaluation conference in your arena? I know you do mostly accessibility with websites, but are you hearing of anybody going to the early evaluation conferences?
A little bit, but I'm not familiar enough to speak to that and kind of like the rate at which those are going forward. But I have heard a little bit of that. Yeah,
I'm starting to see an increase in it. Originally, I was thinking that people were not using it, but I'm starting to hear that percolate a little bit more. So just wondered from your perspective if they had heard about it. Since your specialty is, both of you, in labor law, one of the big questions, although it doesn't have much to do with our world of accessibility, we still get asked questions that are out of it, just like you guys. When an employee comes in and they have a disability, and they say that they cannot wear the mask. I know that it's an evolving, changing rules and regs right now, especially with all the new OSHA stuff that came out. What should an employer say?
Well, so under the ADA, obviously the issue of masks hasn't really made its way through the courts yet. But under the ADA, an employer has an obligation to engage in interactive process with its employees. And that process is to determine whether or not there's a reasonable accommodation that you can make for that employee. So, it depends on what the employee does, first of all, and, where they're working. But an example of a reasonable accommodation would be if an employee, if your workplace requires masks and that employee has a separate space where they can work away from everybody else, a reasonable accommodation would be to let them not wear a mask in their separate workspace. Or obviously remote work is always a reasonable accommodation, right? If they're able to perform their job remotely, then that would solve the issue as well. But the employer's obligation is to engage in interactive process to determine if there's a reasonable accommodation available to them that is not an undue burden on the employer. So it's a give and take process.
Right. And Harrison, are you starting to see a lot of cases of, where you're covering employers where they've got employees that are saying they're afraid to go back to work? Are there cases that are out? I mean, what are you advising employers to say to these people that are saying, I'm afraid to go back?
That is a tough question to answer. So I personally haven't seen a lot of those cases yet. I expect kind of more things will come. With like anything, companies have to kind of draw a line in the sand and determine what they want to do going forward. Do they want to have a full return to office? Do they want to have permanent remote? Do they want to have some kind of hybrid system? And then it really comes down, that's, a management decision. And looking at the business model, the safety of their workers, the safety of their customers, A law firm, for instance, where you rarely have customers on site, maybe some vendors, is going to kind of operate differently from a restaurant. So these are all things that companies should keep in mind. But there's really, like everything in the law, there's so much gray area, so much depends on kind of the goals of the customer, of the business, of the client, that you got to really keep all those things in mind when kind of advising.
Right. I did a seminar yesterday, and that was one of the questions that came up. And, I always go back to, you need to reach your legal and find out what they want you to say based on your type of business. And if you don't, and you take the advice from someone that doesn't have the exact type of business that you do, then you might get yourself in some trouble. And he said, so if I go back to my, my business today, and someone says that to me, do I just look at them with a blank face? I mean, I get it. They're struggling. Nobody wants to make a wrong move. So it's just, I can't imagine what you guys are even having to go through right now with all of the labor questions and things that are coming up when everything is so gray and evolving. It's so kudos to you guys for trying to keep up with all of it, because we get questions. I just keep pushing it to you guys. I don't know what else to do at this point. Other than to do that, because I'm afraid even to say the wrong thing to them. I don't want to give bad advice, so we don't give advice. We just, shuffle them on to you guys. So.
I think that's why it's year 2 of law school when you guys learn to tap dance, right?
That's right.
I think to Sean's point, though, I think a good starting point always is to have an individualized conversation with the person at issue. Someone has a fear of going back, is it because they have a disability that could put them at higher risk, or is it just, their ideological fear? You got to really look into the facts, and when in doubt, talk directly with the person, ideally with a lawyer present, or, in consultation with a lawyer.
Sure.
I'd like to circle back for a minute, if we could, back to a comment that you guys made, and I preach, and I know Tracey preaches, is finding people that specialize in these individual little nuances of law. Even though people may be employer or employee labor, they may not have experience with the physical or the digital ADA. And I know you guys are all licensed in different federal circuits, but let's say somebody is sued that's right down the street from Harrison, and they're sued by a plaintiff in Pennsylvania, in Illinois, in Colorado. Can you still consult with that until it gets to a certain level? And the reason I ask that is I've dealt with too many people over the last couple of years that have been sued in these new areas. They reach out to an attorney in that area to defend them that really doesn't have experience with them. And all of a sudden we're looking at big retainers and stuff like this. Instead of trying to be aggressive and get something taken care of quickly, they're sitting back and handling things, maybe not in the way that someone like you guys that has experience would handle it.
Best practice obviously is if you're sued in a particular jurisdiction, it's ideal to find an attorney who practices in that jurisdiction, right? And that's because the courts, the judges, the players, right? If you do have an attorney that you like working with that has helped you with these similar matters in the past, great, you can work with them as well, but they'll probably want to get local counsel in a specific jurisdiction if you don't practice there.
Don't you think it'd be the best foot forward, though, to contact somebody in one of these states that has a lot more litigation, like one of you guys, and that way, if nothing else, you could vet the local attorney maybe for them so that that they're doing what's needed to be done in these certain instances?
Well, the number of people who do this sort of defense work, it's not a huge number of people. So we all kind of know the players. Mm-hmm. So if you do, if I happen to get a client reached out to me that, is sued in a jurisdiction that we don't have any attorneys in, then, I know who to kind of look out for as far as local counsel goes. So we all kind of know who the players are in what jurisdiction.
I just think that's important because I dealt with a poor lady about a year ago that was up in Northern California, had a website that wasn't producing revenue, was sued out of Pennsylvania, and I think they were looking for $40,000 or $50,000 to settle, and she paid out $15,000 for a retainer and had not made that much money off the website. So instead of taking money for her, I advised her to shut the website down. I mean, if it's not making revenue, why continue?
It's always a surefire defense to the lawsuit. The website doesn't exist anymore.
Mm-hmm. So what are you guys seeing as far as physical lawsuits following digital or digital following lawsuits? Kind of once they get on the radar with one part of the business, it follows up, whether it be with the same plaintiff or a different plaintiff, and adding on to another petition or complaint.
So I haven't seen a lot of that. A lot of physical following digital. The main players, it usually is retailers being sued, typically in the digital anyway, and they're also the prime targets for physical because they have the physical stores. So I don't necessarily see a connection between the two, but it is the same players that are frequently targeted.
How about California?
Same exact thing.
Yeah, I see it for sure. I see where someone says, yeah, last year I got, hit on my website and now, and sometimes it's from the same law firm. Sometimes it's not. But it's really a really unfortunate thing. It's just so hard to be in business right now. It's not as if it wasn't hard in California already. I've never, lived in New York, so I know it's expensive there, but just all of our rules and especially now with all of the new stuff, it's just very difficult to be in business in California, but we keep supporting them and, we need business. And so we all, work together to support that these businesses continue on. We want to help them succeed. And I think our biggest message is when an employer or a business has a question, to know that they do have a resource to ask questions and that we're there for them. And on the other side, for the disabled, we want to be there and understand what their needs are so that we can then express that to the businesses and help them understand how they can increase their revenue, especially if they're struggling, and make it better for everyone. Especially we have such an aging population that's heading up there right now. At some point in our life, we're going to have some sort of disability, whether that be we're going to lose our hearing, or it just means that we're ignoring our family, or that our eyesight goes. I mean, just with age, we naturally get what's considered a disability by that. And so supporting that industry, I think, is so important. And I certainly appreciate and that you guys went to school and that we have resources and legal to depend on with you guys. And just so that you guys know, we are here as a resource out on the streets and that we're helping educate them. And so I always appreciate that you guys come in and help us with that. I know we work together a lot, Glen and I, because we're in completely different worlds. We're always trying to learn about each other's worlds just so that we can answer those questions. So thank you for what you guys do.
One question that I hear from plaintiff people, and it's probably just more inquisitive, are there limits federally or locally through state courts on how many lawsuits a particular plaintiff can file over a period of time?
Not in New York. If you file too many, though, the judges may start yelling at you. But I know plaintiffs filed upwards of a few hundred. So if they have a legitimate basis to bring the suit, they can bring the suit. The more you bring, obviously, the less harder it is to prove damage, right?
Mm-hmm.
Yeah, and out here, there's a mechanism to address that. If someone files enough lawsuits in a certain time frame, they can be deemed a vexatious litigant. But there's some case law suggesting that for these ADA suits, that's not really a concern. And what I'm seeing now is when a plaintiff files a complaint, I've seen that as a footnote. I'm not a vexatious litigant. They just admit it right up front. I've filed 300 of these cases, but that's allowed under the law, kind of thing. So, unfortunately, that's not really a great defense tactic at this point.
Yeah, it's always interesting that we hear from business owners when they're done, either this attorney is known for this, and they see complaints or stuff like this, or this litigant and things like that. And it's always, I'm sure as you guys know, you're part counselor, part doing work for people to try and get them to focus on what's important and not focus on things that aren't going to benefit them.
Right. Yeah, it caused a lot of outrage
Absolutely.
when a client finds out that they're being sued.
Can one of you outline kind of once you have a case filed, an ADA case of any type filed against them, what are kind of the steps that you go through to get to, because you know the majority of these cases do settle. So what are the steps that happen? That, you know, someone gets a case, they call you up. What's next?
So first thing I do is I take a look at the website. You know, look at the allegations of complaint, and then compare that to what we do our own review. You know, but usually with a screen reader. But a lot of these plaintiffs just use the Wave tool as their initial way to, you know, put the complaint together. So we do both. We check the website out with the screen reader and with the Wave tool to see if there's really are issues, and then we can work with the client to rectify those issues. And then, you know, once you get into litigation, then it becomes a business decision at the end of the day. You know, if we rectify those issues, do they want to fight it, and you want to, you know, try to dismiss the case, or is it better, you know, from a business perspective to engage in settlement discussions?
Sure.
And that's exactly right. That's our, you know, kind of go-to strategy as well.
In your opinion or experience right now, what percentage of these do you see actually being fought and actually going to trial versus settle?
Very few go to trial. The lion's share are resolved at some point during the litigation.
And I think for our general public, I know this is a wide variety or guesstimate, but typically if you're going to a trial, I'm assuming primarily they're going to request a jury trial versus a bench trial. What is the estimate in New York or California of the cost someone's going to get involved if they actually go to a jury trial?
So like the cost of
counsel?
Yeah, the counsel that they're going to incur by wanting to fight something like this.
Well, the attorney's fees will get very high. You know, if you litigate something through trial, you know, hundreds of thousands of dollars in attorney's fees.
I just wonder, because I was involved in something with a previous employer years back or whatever, and my fraternity brother was an attorney, just said, you know, basically you're going to go to trial for this for a week's trial, you're going to look at $25,000. Now this was the Midwest where things are a little bit more conservative, but I think that's why some people, I think, have a hard time understanding of why they pay for these settlements. It's because it's the lesser of evils. Is that fair?
Well, you know, it depends. A lot of it depends on, you know, what the business wants to do. You know, I don't think most businesses like having litigation pending against them. So it just becomes just a business decision at the end of the day. You know, what makes sense for them. But you know, trial is very expensive. There's no doubt about that.
And it's not just financial penalties. I mean, you have emotional penalties from going with and dealing through these things as well that are going to detract from their businesses. So sometimes,
right? It's a nuisance for your employees that have to participate. You know, there's a lot that goes into it.
Yeah, they'll want to take depositions. Maybe they'll want to, you know, get discovery going, which you might have to have your employees kind of look at and deal with. It can be a big disruption, especially for smaller companies that might not have a huge employee base. So that can take real time away.
Yeah, and it is something, you know, right away when somebody has reached out to legal, they'll call us back and say, you know, they just want us to settle and that's expensive and I can't do that. And, you know, you kind of have to give them that verbal hug and say, just for a moment, you're going to need to take the emotion out of it. And you're going to have to make a serious business decision. And if you talk to them about, you know, fighting it because they're really angry financially, they're being honest with you. I mean, a lawyer's being honest with you is if he's saying we need to get rid of this fast and furious, and it's still going to cost, it's still going to hurt, but you're going to get it behind you. And now you're going to be able to make a plan to decrease that from ever happening to you again. And I imagine that's a daily conversation that you have to have with clients on your side of it. We certainly see it and have had to learn to do that on our side as well.
I think I reached out to you and we visited about this a little bit in the past, Harrison. I'm interested, Sean, if you've heard about this and if we're seeing this out in New York as well. We have an attorney in San Diego and a gentleman in a wheelchair that has sued a numerous amount of hotels this year for not having enough of a description of if they can book a room based upon their wheelchair and their mobility. Are you guys seeing that in New York as well?
Yeah, they're having a lot of cases about that. Yeah, it's about how descriptive is your hotel website about what accessible features you have. They're having a lot of cases, and I don't know the specifics of it. I know a judge in the Northern District just a few days ago dismissed like 17 of these cases, finding that the plaintiff didn't have standing because they were based in, states that were not New York. So I don't know specifically the case, unfortunately, off the top of my head, but I know some of the judges are pushing back against those.
And do you guys both see this as, again, another gray area until we have a precedent of a trial of something like this coming down, that these are just going to continue to grow and kind of be another kind of legal extortion just for settlements?
Well, the regs on those are very vague, right?
Mm-hmm.
It doesn't say exactly what you need to have in a description. So that leaves the gray area for these lawsuits. So yeah, I think as long as the regs stay vague like that, you're going to see these types of lawsuits until you get a more definitive ruling from a court.
Yeah.
I think.
No, go ahead. No, go ahead.
I was just say, so I think the issue with this kind of area of the law in particular is, you get a lot of lawsuits when there's vague law and or when it's hard to apply the facts to the law. So right now, we don't really even have a guiding legal principle. We have some guidelines, but not any hard and fast rules, kind of. So it's really hard because does your website comply? Is your website descriptive enough? Well, we don't even know the standards to comply with. But even if we had kind of like a 10 commandments, this is what you have to do, then it becomes a fact question. Did you in fact do that? And, as we talked about with apps, with new technology, with evolving theories, it's exceedingly difficult, even if you had those clear guidelines, to kind of establish, yes, we in fact complied. So these kind of cases aren't going anywhere for a long time.
I'm disappointed. I thought you guys would have a better answer to that, because when I spoke with the ADA's Department of the DOJ and asked them what the criteria was, they said I should ask an attorney.
The criteria is right in the regs, so.
That was their answer.
Yeah, that's pretty. You can imagine how frustrating that is for a business owner who asks that same question, calls the DOJ and asks those questions, and why, and then they referred back to an attorney it says just like that. It's kind of being stuck on the merry-go-round. Nobody seems to have an answer, so you're just playing at risk. So
right. I mean, obviously, you want to be as descriptive as you can. So that's the best advice. As much description as you can put in there, you should put it.
And I say to them, if you're going to put it, would you please actually have that at your building? Because I can't tell you how many hotels right now are putting stuff on, and then we'll go there and we'll actually do. And I was like, you don't even have that. You don't have a communication room. Why do you have that on there? Well, they said we had to have it on. Right. But you actually need to have that. So if somebody arrives, thinks you have that, sometimes you have to shake your head like, but so, yeah. And in California, we have some of those codes are a little more strict. They actually go above and beyond the ADA. And so if you get a big firm like a Marriott or a Hyatt and stuff, and they use architects and things like that out of another state, we often find that when we go in for the final inspection that they don't pass, and then they don't know why, and we're asking them to tear things out. So I always also, talk to some of these big firms and say, yeah, I know you get to do that in Kentucky, but, we're here in California, and some of our codes for accessibility are more strict. So make sure that you always check in California if you have, in other areas. And do you find the same way? Do you guys have different local codes that are somewhat a little more strict than the ADA?
Yeah, not in the same way that California does. Obviously, all cities have building codes.
Right.
They're not necessarily focused on accessibility. Whereas the California code, I understand, is. So obviously, you have to meet the building code, and then really, as far as accessibility goes, you have to think about the ADA.
Right.
A question that I hear a lot about digital is when is it the customer's responsibility and when is the platform responsibility? So let's say a Facebook business page, a Wix website, a Shopify website, and stuff like this. Do most of these companies have terms and conditions that we've kind of grown accustomed to glazing over and just checking and not paying attention to them? Or when do people know when it's their responsibility versus a platform?
In terms of...
yeah, I'm not sure the question.
So let's say my Facebook page has something on there that doesn't work for a blind person. Is that my responsibility? Is that Facebook's responsibility? my Shopify store has something that doesn't work for a blind person. Is that my responsibility? Is that Shopify's responsibility? My typical response to them is, did you read the terms and conditions when you signed up for that page, when you signed up for that website? Because I think we've all become numb to terms and conditions and we just check them and no one pays attention anymore.
Yeah, and I think you're right. I think the terms and conditions of the website would dictate, who's responsible for what. So I think that would be a good place to start. And my guess is that, the terms and conditions say that you're responsible, not the website.
So maybe the large company with a big legal team is probably taking care of that?
Probably, yeah.
Yeah. You have to say, yep, they got a good legal team.
Yeah,
I know. Go ahead.
Yeah, I was going to say, a lot of something I've seen is a well-drafted terms and conditions site or portion of a website that includes, let's say, a venue selection clause or a form selection clause. And perhaps, any lawsuit has to be brought in a state without statutory penalties like the Unruh Act has, things like that, or an arbitration clause. Those kind of techniques can be used to kind of fend off lawsuits. And I'm seeing more big firms and people with legal advice kind of go that direction.
So if we touch on one last thing here before we leave, because we don't want to keep you guys too long. I know with privacy seems to be moving across the country. So whether it be the CCPA, the California Consumer Privacy Act that started January of last year, I know I keep getting notifications. I think it was in 13 different states here in the last 90 days as far as having different privacy laws. How do you guys see that kind of changing the landscape of the internet? That I keep telling people the wild, wild west isn't here anymore between accessibility and privacy. They're going to have to be a little bit more compliance centric. And to what levels are you seeing these? Because I know there's a lot of different interpretations of CCPA as far as size of business and who needs to really be cognizant of terms, conditions, privacy policies, cookies, and things like that we kind of visited about a little bit.
I'll have to defer to Harrison on the CCPA, but in New York, I don't believe they passed a similar privacy law. So at least our New York clients aren't necessarily targeted in on that. But that is the change. That is what's becoming the way of the future, right? So you just need to work with your legal team to make sure that whatever information you are collecting of your customers, that does comply with whatever state you're doing business in.
Mm-hmm.
Yeah, and the CCPA is kind of like the hot mess of the legal world out here, and it's really difficult for people who are focused on business to run a business and keep track of all these laws that change all the time, city by city, county by county, state by state. Companies rarely do business in just one place anymore, so there's a lot to keep in mind. And I think a takeaway from this conversation could be consult. Talk to people, talk to experts, because you don't know what you don't know, and that can hurt you a lot.
Amen. Yeah, trust me, I've given too many presentations in the last 3 years about accessibility, and then we start talking about compliance, and I've heard more than one time, could I come with something positive to talk about instead of all these different regulatory issues? Well, we very much appreciate you guys coming on board from coast to coast. We're actually west to east today, so this has been kind of fun. If anybody would want to reach out to either of you to ask for advice, to hire you guys or whatever, what's the best way to communicate or get in contact with each of you?
So I can be reached by my email. It's skirby, Kirby, at shepherdmullen.com. And my information is available on Shepherd Mullen's website.
Likewise, my email address is hthorne, THORNE, at shepherdmullen.com, and my phone number and all that's on the website as well.
Well, thank you guys. It's always good to have expert opinions and input on this, just because, again, you keep mentioning some gray areas for our business owners. It's a bigger gray area. They really have a hard time wrapping their hands around this with all the different obstacles and all the different trials they're having as running business owners in today's market. So we really appreciate you taking some time. If you hear anything about any of these different nuances or whatever, please reach out and share them with us, or let us know when would be a good time to bring you back on again, because I think the more we can keep people informed and educated, the better it'll be for everyone.
Absolutely.
Thanks for having us.
Yeah, again, thank you guys
Thank you for having us.
All right, guys, take care. For everyone, we'll see you back here, same time, same locations next week. Have a great week, everyone.